Good morning, welcome, and thank you for joining us today for Impacts of COVID-19 on Litigation Economic Damages. Before we begin, we do want to go over a few housekeeping items. A link to the recording, as well as the slide deck, will be emailed to everyone later today. You can also download the slide deck now in the handouts section of your control panel, which can be accessed from the right side of your screen. If you have any questions during the webinar, please type those into the questions panel, which can be accessed in the same control panel. We will have a Q&A after our prepared presentation to address live questions and any questions we received prior to the webinar. After the webinar concludes, you'll see a survey for our program. If you have a minute, we would love your feedback on today's program. This helps us improve our future programming and figure out what topics you're interested in. This program has also been approved for 1 hour of general California CLE credit. If you would like credit for today's presentation, please note you must attend the entire webinar and answer all of our periodic polling questions. We will send you a completion certificate within a week after we are able to verify all of our attendance records. Now I'd like to introduce myself and my panelists. My name is Natalie Maples. I am an associate in Nossaman's real estate group. I counsel clients on a wide spectrum of real estate transactions, including issues related to site acquisition and development, land use, mergers and acquisitions, and commercial and residential leasing. Patrick Richard is a partner and co-chair of Nossaman's corporate group. He has more than 3 decades of experience as a commercial trial lawyer, and he has successfully represented publicly traded companies, individuals and government agencies as both defendants and plaintiffs on a broad range of commercial disputes, from complex business transactions and corporate governance to breach of fiduciary duty and business tort actions. We are joined by Peter Brown, who leads GHJ's forensic services practice and has extensive experience quantifying damages in commercial litigation and conducting internal investigations. He has served as an expert witness in a variety of matters and as a third-party neutral regarding accounting matters and purchase disputes. So we're going to go through 3 hypotheticals today. The first is the so-called sinking building hypothetical. Second, we will look at a surgery center. And third, we're going to look at food and beverage industry, in particular 2 restaurants. And also to introduce the topics that we're going to go through today. We're going to provide an analysis of COVID-19 related losses and what you can do about it, how the damages may differ for a temporary business interruption versus permanent, how to prove in a court of law what you're owed and by whom, as well as best practices and strategies for working with outside accountants and other expert witnesses. The first, the sinking building hypothetical, and here are our assumed facts. Sally LLC sold an office building to Berry Inc. for $100 million with a closing date of February 15th, 2020. Sally failed to disclose a consultant's report showing the building had started to sink due to local soil conditions and would continue to sink. By year-end 2020, when sinking had become obvious, over half of the commercial tenants had given notice to terminate long-term leases. Many tenants had planned on downsizing due to COVID, but 2 of the tenants wanted to move into cheaper, larger spaces. The first floor restaurant had closed due to local order, but had reopened by the time Berry filed its fraud and breach of contract complaint. The damages claims are as follows. Berry has asked for a legal and economic analysis of his damages for an upcoming mediation, and the mediator has asked for us to focus on 2 questions. First, how is she supposed to evaluate the impacts of losses due to COVID as distinguished from the sinking? And second, what is the appropriate way to determine damages, assuming that liability is established? So as Patrick and anyone attending from San Francisco can attest, this is a real issue, the so-called sinking building. So first, I'm going to have Patrick give us an overview of causation and the legal issues.
So yeah, this scenario, thank you, Natalie. This scenario raised, and this is from an actual case that I worked on, raises the question of causation. And I think as these cases make their way through the courts, you'll see the 2 bookends of causation raised by this hypothetical. One is, if I'm the plaintiff, I don't have to prove that the fraud was the only cause, but that it was a substantial factor. And the same will be true in negligence claims as well. Whereas defendants will say COVID is a superseding intervening cause. And we'll talk about that throughout our discussion today. But those are kind of the bookends of causation. And this scenario also raises the question of, you want to make sure your expert is lined up with a reasonable methodology. There are cases that, especially in the real estate context, if it's early in that process, say it's development or acquisition, I would have made $1 billion acquiring this property. Courts are going to have an issue with that, and so you'll want to rely on your expert. But I think this scenario primarily raises this question of, was it the COVID? Was it a shutdown order? Or was it this sinking building that made it impractical for the tenants to continue there? And the buyer is going to have a choice of, showing that there's a wrong, which this hypothetical assumes. The buyer going into this mediation is going to want to present different scenarios, including maybe just getting out of this deal, going for rescission.
So on the next slide, we have some alternate remedies available to the buyer. Patrick, what are the different legal standards based on the nature of the loss?
Sure. Normally, if you ask, a judge or a mediator, what are the damages for fraud? She'll be inclined to say, well, you just get your out-of-pockets. You're not going to get lost profits. But having attended this seminar, you'll be familiar with the Civil Code section that says not for purchase of real estate. You can get basically what is lost profits. It's right in the statute. But you also want to back up to say, Judge, and if you have an issue with my expert on either of these things, at a minimum, I should be able to undo the deal and get give them back the building and get my money back. And that threat, I think, would have gain some traction during the mediation as well.
Peter, from your perspective, the fraud and the contract damages are probably going to be the same number, but for rescission, the damages would be different. Why is that?
Well, it's interesting. And hi, everybody. Thanks for having me. And thanks to Nossaman for co-presenting today. And welcome. Yeah, with respect to fraud and contract damages, they're really going to be the same thing from an accountant's perspective in California. With the fraud damages, you do get lost profits. And also with contract damages, you get lost profits as well because they're part of consequential damages. So just by the law, it says you can get those. With respect to rescission, it's a little different because at the end of the day, what you're going to do is unwind the deal. So what's going to happen is essentially the buyer is going to give back the building and the seller is going to get that building back plus out-of-pocket expenses. So that's what's going to happen in rescission.
So on the next slide, we have an evaluation of the measure of damages. At what point in this scenario does the measure of damages become too speculative? So first, we're going to have Patrick go through some of the legal concepts that apply to that analysis.
Right, and again, the nature of the argument for this mediation turns on whether you're the plaintiff or the defendant. The plaintiff will identify, well, the fact of damages is certain, and there is no bright line for the measure of damages. I just need a reasonable approach or reasonable methodology. Defendants, in cases where damages is at issue and there's an impact from COVID, will say that's just too speculative, or the expert didn't take into account COVID, the impact of COVID, or a shutdown order. Or if they did take it into account, they didn't take it into account appropriately or sufficiently. So again, these are the general parameters. You don't need to prove your damages with mathematical certainty, but you certainly need a reliable methodology. And I think that COVID's going to bring this issue up anew as these cases make their way through the system.
Peter, from your perspective, what would actual certainty versus reasonable certainty look like, and what is a reasonable basis for estimation?
Well, thanks. That's a good question. I think, absolute certainty is not possible, right? Particularly when you're looking at future damages or what's going to happen in the future, you're not going to know with absolute certainty. So it's reasonable certainty is the standard. And I think there's really two tests that have to be made. The first is, did you actually suffer any damage that can reasonably be tied to what you're claiming? So you have a claim for damages. are the damages that you're claiming reasonable, and are they tied to that? So that's the first hurdle, which is a pretty, high bar to cross. But once you get there, I think you then look at what's a reasonable methodology, and you can look to establish methods for doing that. So a little higher bar initially, but once you get over that bar, then you have a choice of methodologies you can use that are reasonably accepted.
And with that in mind, we're going to go to the next slide, which is an analysis of the impacts of COVID as opposed to the sinking. So first, looking at COVID, Peter, what impact would that have on lease rates and cap rates?
Well, it's interesting. I mean, there's been a lot of studies that have been done on this. And the reason we chose this example is because it really has two different things going on. You have a building that's sinking, right? So you have impact from that. And then you couple that with what's going on with COVID. Now, with respect to COVID, there's actually a fair amount of empirical data out there now that tells you what's really happened. So you can get studies that they've done with respect to lease rates, cap rates. I just saw a study this morning. It was on a sublease activity. And so that would be another measure of whether or not there's been an impact to a real estate market. So there's really good information out there with respect to what COVID has done to the real estate market. So it's a good, it's something you can rely upon. With respect to cap rates, which is really sort of a return investment. So on cap rate, basically, you just take the net operating income of a building. Let's say you expected to have $300,000 in rent, but then you had $200,000 in expenses. So you get $100,000 in net income. If you divide that by the value of the building or what you paid for it, that's your cap rate. So let's say you paid $1 million for the building. If you had $100,000 NOI and you had $1 million building, that's a 10% cap rate. So use that. Now, what you would do is sort of compare that. What's happened to cap rates since COVID? Well, it's interesting. It depends on what part of the commercial real estate market you're in, right? If you're in downtown San Francisco or in New York City, office space has really taken a hit. So in those instances, cap rates have gone up. Because people are demanding that they have more of a return on their investment. And number two, there's been a reduction in the value of, so the denominator has gotten lower, so the cap rate has gone up. However, if you look at what's going on in industrial space, if you look at warehousing space in particular, let's look at Southern California, for instance. There was a building that I'm aware of, just read an article in LA Business Journal. It was bought for $40 million in 2019. And it was sold for $80 million in 2020. And what was the difference? The only difference was it got a lease from Amazon to do the last mile delivery, and it doubled the value of the building. So it depends on what part of the market you're in with respect to commercial real estate. The other thing you have to look at is whether you have a permanent impact or a temporary impact. And I think most people would view COVID at this point as being a temporary impact. If you look at the sinking, there could be some permanent damage to that building, and maybe we could look at a chart that would show us how to view that. So if you look at this chart, and it's kind of difficult to conceptualize this, but let's assume you're a buyer, and really what you're buying at the end of the day is a set of cash flows that go into the future. So if you view this entire wedge, this entire chart, is the cash flow that you expected to get when you bought the building. So everything going out in the future, you're going to expect to get some future rents increases. So it's going out in the future, it's going to be great. What we've modeled here is really a fact that the building has had a permanent impact. So if you look at the blue portion of this chart here, that's the cash flow that you're actually going to get from the building, because you've had tenants that have left, you're going to have a major remediation project, and you essentially what we've modeled here is a permanent impact. So you never did get that total wedge, the green plus the yellow. Then you look at the green and the yellow, what do those represent? Well, the green really represents all those tenants that have left, and they've left for different reasons. Some of those tenants have left because of COVID. And so what the COVID section in is really that yellow section, where we're saying if you equate, let's say, number 3 on that bottom axis to March of last year, you saw that there was an impact of businesses that went down. They started to pull back up, and then going into last summer, again, there was another impact. So the challenge for the damage expert is to understand to be able to separate what's the impact from the sinking versus what's the impact from COVID. And you can use charts like this to actually demonstrate that.
So looking at the yellow wedge, and this is a concept that's going to come up in all three of our hypotheticals, with the disparate impacts of COVID, as well as COVID being a temporary issue, how do you determine when business gets back to normal? When does that yellow wedge become green?
Well, I mean, obviously it's a subjective analysis, and you have to do something that's reasonable. If you ask me as an expert today, with all the evidence that's available out there, I would say that COVID is going to be a temporary impact. I see signs that things are coming back. I think the economy is going to roar back in 2021. And so for me as a damage expert, I am not going to be modeling a severe impact from COVID going forward. But you have to take each situation into consideration. In general, I think the economy is going to recover. And I think that people that are modeling damages into the future should assume that COVID is going away.
So turning to the sinking issue, the more permanent issue, Patrick, for the sinking, what facts are you going to rely on your experts to provide?
Sure, and I think, for the trial lawyer representing someone in this scenario going into a mediation, you cannot rely just on your accounting expert, your damages expert. Your case will be strengthened by having a causation expert, right? An industry expert who can testify specifically to other buildings that have had sinking. I mean, in the case we had, it's a real challenge to try to quantify. You'll have real estate brokers in San Francisco tell you, well, every tall building leans a few inches and no one seems to notice. But then you had the Millennial Tower, which ended up on 60 Minutes because a marble could roll across the floor in the penthouse. No one wants that. And ultimately, you have to get sufficient market data. But this is a common theme throughout these scenarios. And I would say the impact of COVID more than ever, you will want that causation or additional expert so that your damages expert has that much more data to rely on. They can point to, well, look, I'm relying on this industry expert. You may do a survey. There are ways to shore up what might otherwise be a speculative exercise.
Yeah, and this is a good example where you're going to need really two experts in this case, right? Myself as a financial expert really cannot testify to the impact of sinking. That's really an engineering and construction industry expert to be able to testify to that. I can take that information and then rely upon it and then go ahead and use that in my damage study. But to determine what the individual impact is, let's say to each of the tenants in the building, you're going to want to get some industry expertise for that.
And I think one other point of the scenario was for the plaintiff's lawyer who comes in and just has a one-size-fits-all approach, they're going to get hurt because the defendant's going to say there were some tenants who their business improved as a result of COVID, right? The Amazons of the world. So it's going to require a tenant-by-tenant analysis rather than a broad brushstroke approach.
Sure. And then to wrap up the discussion, this is another issue that's going to pop up in all three of our hypotheticals. How does COVID factor in as a superseding or intervening cause, and how would that factor into the defense for the damage calculation in this scenario?
Sure. And here, you're as the litigator, you're always casting about for the right analogy. And so just to back up, a superseding intervening cause is a principle that arose out of primarily personal injury cases where I may be negligent, but I get off the hook because something worse came along later and cut off my negligence. There's a case where a highway patrolman pulled someone over. They were off the freeway, and then a drunk driver hit the car into the highway patrolman, unfortunately. And the question was, can you sue the original driver that he pulled over who was driving erratically? And the court said, no, the superseding intervening cause was that drunk driver who came on the scene. Well, defendants during the financial crisis argued that the Great Recession of 2007, 8, 9 was a superseding intervening cause that overtook their negligence, right? If I'm a banker and I made bad loans, the loans didn't fail because of my negligence. It was this tsunami event that no one could have predicted, this worldwide financial crisis. Well, now we have a worldwide pandemic. And if I'm the negligent defendant, I can point to, regardless of what I would have done, this pandemic and these closure orders are really a superseding intervening cause that gets me off the hook. So I think that we'll certainly be seeing this doctrine. And there are cases from around the country that dealt with it. Most of them rejected that the financial crisis was a superseding intervening cause. But I think there was a case or two out of Texas that said, no, that's a new one. And so the question is this subsequent event something that was unforeseen, unpredictable, such that it cuts off a notion of fair causation?
Thank you, Patrick. I like the likening COVID to a drunk driver. I think a lot of us would agree with that assessment. This brings us to our first polling question. One of the key elements of our discussion is, when is business back to normal? So our first polling question is, in your personal estimation, when do you anticipate non-essential employees will return to the office at full capacity? And basically the options are the next 4 quarters, or there will be continuing impacts and we're never going to be back to normal. So take a moment, answer the poll, and we'll post the results as soon as they're all in.
Peter, you can't vote.
I already did, though, earlier in the webinar.
All right, so a pretty even spread here, which is interesting. Peter and Patrick, do you have any thoughts on when you anticipate we'll return?
Well, it's interesting. My first response is, this is the type of information that I would want to have if I was taking a case to trial that raised these issues. This was basically an informal, survey of a potential jury pool. But I just, my sense off the cuff was Q1 2022. But you can see that there's a bit of a spectrum there between optimists and pessimists.
Yeah, for me, it's interesting. I don't know that businesses are going to keep all of their office space. I think a lot of businesses are going to go to this hybrid model where they're going to allow folks to work from home, some portion of the week, let's say. It's interesting. I kind of went whole hog on this. I just hired a staff member who lives in Tampa, Florida. So this person will be remote permanently, right? And so I think there's some of that going on as well.
Interesting. So now it's time for our second hypothetical, which is the surgery center. And here are our assumed facts. New Medical Services, Inc. buys, sells, and manages outpatient surgery centers. CEO Don is excited to assemble a group of high-volume SoCal physicians within a new surgery center. After these physicians sign a term sheet, but before diligence is completed, an unscrupulous competitor solicits these physicians to a new location with false accusations of criminal investigations. New Medical then sues for defamation and tortious interference. The defendant argues that the COVID-related slowdown and closures make any lost profit damages inherently speculative. And the defendant also admits he was misinformed and has offered to issue a retraction and correction. There are a couple of issues related to potential damages in this scenario. The first is whether future damages are barred based on the principle that the success of any new business is inherently speculative. And the second is what steps can be taken to avoid having your expert's testimony excluded. So first, Patrick, I'd like for you to explain the practical issues that pop up in this scenario, as well as the legal standards that would apply.
Sure. There's a famous treatise on damages, Done on Damages, and others, that if you looked at the edition from the 60s, they would say the majority rule across the country was that an unestablished business claiming lost profits, that was inherently too speculative. And as a practical matter, there are still judges and practitioners in California that have a presumption, but not an absolute rule, that a new business is simply too speculative. And I think it depends on the business. We talked about real estate development. You know, if you're talking about acquiring a undeveloped piece of property and you think you're going to develop it into a $1 billion project, that's probably, your expert is either going to be excluded or you're not going to be able to satisfy that standard. So as a practical matter in this scenario, you know, you would want to argue it's not really a new business, you know, and you're going to need to rely on established data rather than just an expert making assumptions going forward. There are just too many risk factors for a new business to have your damages expert assume that, and this is really the Sargon case, California Supreme Court in 2012, your damages expert simply cannot assume that a small business is going to become one of the top 6 players in the field. And so this is a case that every practitioner, you know, just needs to be familiar with. Some plaintiffs have stars in their eyes, and their damages expert will talk them down and say, no, that's not a reasonable assumption. Courts will exclude that expert. You can't come in and say, I have a new dental implant for a small business, and in a few years I'm going to, you know, be a major player, and I lost $1 billion because the university didn't complete its medical clinical tests of my product. There's just too much speculation in that scenario.
So what would be the difference between a truly brand new business and one that's not new, just newly established?
Well, and that's a question that I'm going to work with my expert on to establish. And if I'm the plaintiff, I'm going to argue this is not a new business. This was just an extension of the physician's existing practice or of the franchise or of some other model. You're looking for ways as the plaintiff to reassure the judge, my expert this is a very standard exercise. Business people rely on this same approach for valuation. Nothing out of the ordinary here, Your Honor. And again, as defendant, boy, plaintiff's expert, this is total speculation. They didn't account for the key risk factors. You should exclude them.
And then in this context, we've got the same question about continuing impacts and when does business get back to normal? So Peter, how would the continuing impacts affect both cash flow and the discount rate when calculating damages?
Well, I think in this case, we've got a surgery center. Maybe go to the next slide. And well, let's talk about damage issues here. So just backing up, we have a group of physicians, you know, individual practices, where someone approaches them and says, hey, I'm going to build a new surgery center. Why don't you guys come with me? And they say, okay, I'll sign a term sheet. And then a competitor comes, swoops in and takes them away. So in this instance, we really have lots of data, right? We have established practices of physicians that have a track record. And we can look and see what were they doing from a financial performance perspective, right? We have a set of projections for the new place. Okay, admittedly, that might be somewhat speculative. You would never hear me say that if I was a plaintiff's expert. But and then you have what they actually did when they got swooped away and went to the competitor. So you've got at least 3 sets of data right there. So I would argue that we're not talking about a brand new business here. I would say, you know, you'd get me to, you know, I'd say unestablished maybe, but I would not say new. Unless you had a situation, and I think we kicked this around, let's say you had one of the physicians was just out of medical school in her residency, and she was just going into private practice. Would that be a little bit more speculative? I'd have to say yes. And we might even kick around and say, well, listen, we're not even going to claim damages for her practice because it's really, you know, we don't really understand what she's going to be able to do. But the other more established physicians, certainly we could come up with some data for that. The other thing that's good, I mean, there's a lot of empirical data out there with respect to how surgery centers specifically have been impacted by COVID. And it really depends on what's your specialty, right? If you had purely elective type procedures that you were offering, I mean, those doctors got hit pretty hard when COVID shut down. But if you've got non-elective emergency, you know, stuff that has to get done no matter what, I mean, those doctors continue to practice all the way through. So you really have to look at it on a case-by-case basis.
And just to jump in, Peter's comments are right on point because the California Supreme Court in the Sargon case, where they excluded the expert because he did not take into account certain obvious factors, talked about the Palm Medical Group case where a physician was denied privileges and the court Court of Appeal was able to point to data from the defendants and from other clinics. So it really is a question of how strong is the data and is it reliable, meaning is that a comparable situation? And again, that was really the Sargon issue. You can't make the assumption that a small one of 96 implant businesses in the world, but for these clinical tests not having been completed, would have become one of the top 5 in the world. That was just too big a jump for the court. So Peter's sense of look to things that are comparable, look to the defendant's own data, I think that will allow you to overcome that very real concern about, is this too speculative? Because again, COVID, it's a new ball game, and you're not going to have a precise historic analogy. You know, there will be some inherent speculation in the damages experts' efforts if they don't take into account COVID and rely on appropriate analogies and data.
So Patrick, do you have any specific advice for plaintiffs experts and how they can avoid being excluded?
Well, you should hire Peter. Oh, was that what I was supposed to say at that point, Peter? First of all, it's important to have, some plaintiffs' lawyers or some attorneys in general may rely too heavily on the independent work of their expert without saying, hey, here are the legal bookends, and here's some guidance. You don't want to fall into this Sargon trap, and be familiar with the terminology and facts of those cases, so that the response can be just what Peter outlined. No, I'm not doing that. I have taken into account those risk factors. In fact, I've been very conservative in my assumptions, and here's the data I'm relying on. If you skip that step or paint with too broad a brush, and also there's just the basic, smell test. $1 billion of damages against this university because they didn't finish a couple of clinical tests. So less is more when it comes to plaintiffs expert in these damages scenarios.
Yeah, I would agree with that. If you look at what those physicians, let's say, were doing prior to this new deal, supposed new deal, I wouldn't grow their practice much more than that, and I certainly wouldn't grow it much more than what they were doing at the new place that they went to the competitor, right? So don't have these outlandish growth rates in there, because it looks too speculative. Everyone understands that a new business or unestablished business has some risk, right? So if you want to put forth a compelling case, don't put outlandish assumptions in there. There's going to, that just don't make much sense. So have it be anchored in reality and do something that's reasonable.
Well, and Peter, you'd mentioned that there's a lot of empirical data. If you're the defendant, how do you respond to how much data there is out there to support the plaintiff side?
Well, listen, I think it's case by case, but if I was the defendant, right, in this case, I would say, number one, you'd have to argue, well, I didn't really steal these guys, right? They went with their own free will, and the other deal was just not as good, and they try to weasel out of it. But then you'd have to argue some way where there's really no damage here, and maybe you bring in a situation where here now COVID maybe comes into play. So maybe go to the chart. So one thing you could say is, if you had a business that was totally shut down, right? Everything's shut down because of COVID. It really doesn't matter what the other factors are if your revenue was going to be zero anyway, right? So do you really have damages if we'll get to a restaurant example where if your restaurant shut down and you're not able to operate at all because of a government order, it really doesn't matter what the other external factors are, because your revenue would have been zero in the first place. So if I was the defendant, I would have been pointing to COVID on this one.
And just following on that, and this is something I don't know that we've hit yet on this hypothetical, but it really does depend on the specialty of the docs, right? So for surgery centers, for physicians doing elective procedures, there's no question the data will show that those were delayed due to COVID. And you would absolutely have to take that into account in your damages analysis. Other surgery centers relying on more essential procedures that you could not defer require a different analysis. And if I'm looking at this chart, you might see for those elective procedures that were delayed, then there would be a bump. as things start to reopen and there's a surge in people who had put off their procedures. So again, it's the detail and the attorney, working with the expert to make sure they've taken into account the particulars of these scenarios.
Yeah, but this chart here is more of a plaintiff's, because kind of took it from the plaintiff's perspective. So here you're modeling just not a permanent impact from COVID. So that darker purple section really represents, the loss that you get from COVID, but you show that the business looks like it, returns after COVID.
Mm-hmm.
And one of the concepts that you'll have touched on is that this is not an inherently new business. These are established physicians with an established practice, and not only did they not stop practicing, but we've got data from where they went instead of this surgery center. What happens if the judge disagrees and determines that this is a truly new, untested business?
Mm-hmm. Well, I think, go ahead, Patrick, if you want to answer the legal side.
Well, yeah, just from a legal perspective, if you're the plaintiff, you're going to argue this is not a Sargon situation and really offer the declaration of both your damages expert and an industry expert to allay those fears that this is truly speculative. And, you talk about the facts of Sargon. It was a new untested implant, dental implant. And this is more like a franchise expansion, and there's good data available.
That's what I would argue, that there's lots of data available. And again, just don't make your projections too large, too unreasonable. Come in with a reasonable damage study, that's anchored in facts, and you should be fine.
So this brings us to our second polling question, in which we're going to ask you to be the judge. And which of the following would you classify as a truly new and untested business? A McDonald's franchise at a new location, the AstraZeneca vaccine, a new restaurant with a first-time executive chef, a tech startup that describes itself as the next TikTok, and a new skincare line for millennials produced by Olay, formerly known as Oil of Olay. So which of these would you classify as completely new and untested? All right, and this breakdown is about what we expected when we put this together, but Patrick and Peter, would you like to give us a quick discussion?
Well, sure. I mean, with respect to a McDonald's franchise, obviously there's lots of data out there with respect to how well those do typically, right? With the vaccine, interesting. That's new. It's a new business, right? And typically with the new restaurant as well, with a first-time executive chef, you don't really know how well that's going to do. And then also with a tech startup. But I would agree, like for instance, the new skincare product from Olay, that's got a pretty established company with an established record. I think it's not that speculative. So I kind of agree with these numbers.
Yeah, from my perspective, if I'm working with my expert and if I'm representing the defendant and the plaintiff has opened this new McDonald's franchise, yes, at first blush, that doesn't seem like a new untested business, but maybe the location or management is new. So I'm going to sit down with my expert or my business expert and identify all of the risk factors for this particular business, the location, the management, maybe they had some formation disputes with their LLC, and identify those risk factors and find the one that plaintiff's expert didn't address, and then make my analogy to the Sargon case. So it's interesting to see the response on these questions, which I think generally makes sense, but the devil's in the details as you work through this with your expert.
That's exactly right.
So, I like the positive feedback. Thank you, Natalie.
And then, one of our examples was we had two restaurants on the last example, which leads right into our third hypothetical, the restaurant hypothetical. So we've got the facts here. We've got two restaurants. One is well regarded with a long operating history, and the other is relatively new. The owner, we'll call him Optimistic LLC, hired a new management company, so-called lazy operators, who has performed poorly, leading to lost sales, employee turnover, and employment litigation. Both restaurants closed during COVID. One remained closed, while the other opened for takeout and outdoor dining as permitted by local order. The owner is now suing the management company for losses due to mismanagement. There are two issues that we're going to explore here. First, what special considerations will the damages expert face in this scenario? And second, due to the alleged mismanagement of the restaurant management company, how would engagement of an industry expert impact the analysis for both the plaintiff and the defendant? So, first question is, how would a business interruption claim factor into this analysis?
Is it, who's that for?
Both of y'all can chime in as.
You want to go first, Patrick, or you want me to go?
No, go ahead. I have my thoughts on this.
Well, I mean, it's interesting. If you look at business interruption coming out of COVID, if you asked me this, 12 months ago, I would have said it's going to be the biggest boom ever with respect to litigation. But it really hasn't happened because you look at the policies, and a lot of folks have determined that they just don't have coverage for COVID. And so I don't think it's settled law yet, right? I mean, Patrick, you can comment on that, but a lot of these policies have exclusions for virus and everything else, and so it's been tough for folks to get coverage. And as a result of that, there haven't been a lot of cases.
Right. The questions I fielded, are specific to your policy, but the battlegrounds are the policy may exclude viruses, but the shutdown wasn't due to the virus per se. It was due to the governor's shutdown order. And there's no exclusion for governmental shutdown orders in certain policies. So while this isn't a seminar on, business interruption coverage, that's one of the battle areas. Exclusions have to be specific under California law. And I don't know that would figure into the work I'm doing with my damages expert if I'm the plaintiff suing a manager for mismanagement. I think this hypothetical raises the question that practitioners will have to take into account that the other ones didn't directly address, and that is the liability claim itself turns in part in this scenario on the professional's response to COVID. So for professionals, lawyers, accountants, restaurant managers, a new set of rules came out and they were evolving. And for a restaurant, there are two big factors. One is, did you get your PPP loan? Some folks sat on the sideline and they missed free money, some might say. Well, that goes to the liability of the claim as well as damages. And same thing with the shutdown orders. For a manager who said, well, we're shut down, I don't need to do anything, you're going to have an industry expert who's going to say, wait a minute, you could have been selling alcohol, drive-by alcohol purchases. Who doesn't want that? So these scenarios really ask the question, how is liability impacted by the professional's response or lack of response to COVID opportunities and COVID restrictions?
Yeah, and on the next slide, I think we've got some issues for our damages expert. So here's some questions for the damages expert. If COVID kept the restaurants from operating, are there damages? Our same question about how long until business gets back to normal, and then how do you account for future pandemic-related shutdowns? So I guess we'll start with Patrick, examine some of the legal issues.
Well,
go ahead, Peter. I think this is straight up economic issues, and I think you would address it pretty readily.
Yeah, I mean, listen, it's interesting. We have a situation where, let's say, the government kept the restaurant from opening. It was shut down, and we've got a claim against this new management company, right, that's come in. I would say, listen, you probably don't have any damages. If you're going to be closed anyway and your revenue was going to be zero anyway, I don't know how you get economic damages out of that. And so that would be my view there. I would tell the client I don't think he has a case. Now, Patrick, you may have a different view there. how long is it going to take restaurants to recover? I mean, it depends, obviously. I think the way that, the footprint of the restaurant, I mean, do they have outdoor dining? Have they been able to get through the storm here? What's the actual situation? And with that, I think you really have to go to an industry expert. I would be looking for someone who's like a restaurateur, maybe operating in the same area that these restaurants were operating in, has a track record, was out there, operating during COVID, and can come in with some real valid, I think, opinions as to what could have been done in the current environment. I mean, I would really listen to someone like that if I was a member of a jury or a judge. And then I can, lever off of that expert to say, well, you could have done, outdoor dining because, you could have put up a tent or whatever, or you could have done takeout, you could have done, alcohol takeout, all that kind of stuff. And so I could lever off that, right? But me personally, no one's going to listen to me about being an expert in restaurant unless you want to look at, my bar tabs. And so that's about it. I mean, I don't have industry expertise there. So I'm going to need another expert to come in and help me with that. And then with respect to the issue of future damages, again, I am not thinking that you need, a tremendous tail on when things are going to recover. I think there's some pent up demand there. And I think once things fully open up, I think you're going to see restaurants in general come back. Now, again, case by case scenario, but I think, things are going to basically come back to normal pretty quick. So I am not, in my damage studies, I'm not going to be putting a huge impact for COVID going forward, but I will have a COVID factor. I think you have to acknowledge that it's there. So I think you do it both in your cash flows. So just have a line item in there that, takes money away for COVID, or maybe in some instances you actually had an impact of COVID that was positive. Put that in as a plus. And then also when you're discounting your future cash flows using a discount rate, I would also consider putting a factor in there for COVID, or at least, say that you considered it and this is how you considered it. I don't think you ignore it. I think you have to take it on head on. And I think that's the key.
And Peter, you mentioned that you need another expert, and to me that suggests that we maybe need a second expert to address the standard of care. And Patrick, how would you establish the standard of care with respect to the mismanagement, and what other experts would you bring in?
Sure, and I think there's this interplay between your liability and damages in this case, because COVID for restaurants was not this exogenous independent event that I had no control over. I didn't have control over the government shutdown orders, but in a scenario where some restaurants were able to partially open, that's something you're going to have to look at. So as Peter said, an industry expert is the only way to really overcome that speculation. If you can't point to other restaurants that were able to do something, it would be sheer speculation to say, I know no restaurant in the world was able to do any business, but I still think this one could have. That's not going to pass the smell test. But as we all know, we've all seen those restaurants that adapted and they used their PPP funds to address their expenses, and they were able to adapt. The second guessing will be, okay, they adapted, but they didn't make any money. But you have to follow the evidence in that scenario to get your industry expert in place, and also let that frame your discovery. I mean, that's a bigger discussion, but I bring in an expert early in a case because Peter will say, look, Patrick, I can't offer this opinion without these three key pieces of data. Part of it's another expert. Part of it is getting the defendant to make certain admissions that Peter can then point to. What's better evidence than the defendant's own admissions? So understanding those pitfalls early in the dispute will help and probably lead to early dispute resolution. If you ignore them, it's just a slow pitch for the other side to hit out of the park. You have to address the nuances of this situation.
Yeah, and you both have touched on how fact intensive this analysis is. So going back to the original hypothetical, we had two restaurants, one that stayed closed and the one that reopened and engaged in some of these more creative responses to COVID. I'm going to give you guys a hypothetical. What if the restaurant that reopened kept having to close for 2 weeks at a time and reopen because the employees kept testing positive? And what if it ended up being more expensive to open and close than it would have been to just remain closed the whole time? What would you respond in that situation?
Well, if you ask me from an economic perspective, I think that's a real issue. If you can't cover your food costs and your employee, payroll and basic costs, then you probably shouldn't open, right? So it's really sort of the variable marginal costs, going back to economics 101. So just the basic, food, payroll. If you can't make enough revenue to cover those things, you shouldn't open. You're just going to be losing more money.
I think that the key thing from a liability perspective, Natalie, is for the defendant, in this case, defendant manager, to say, see, you're second guessing. You're saying I should have opened, but some of the folks who did open lost their shirt. So, you're trying to judge me in hindsight. Well, then let's look at the full, let's look at those restaurants that tried to reopen and did not do well. So again, I think that shades into liability as well as damages. And it's going to be a difficult bar to establish. How should you have responded real time as a professional to this developing, changing, in some cases, week to week situation? I think that will be a fact intensive issue.
Mm-hmm.
What about impacts from COVID not related to the shutdown orders, such as the impact of perception? For example, a lot of the service industry folks tested positive and got hit pretty hard when the restaurants did reopen. Is there some stigma associated with that could also impact the analysis?
Mm-hmm. I think stigma is really an important issue, and it remains to be seen if my prediction is that people are going to come roaring back. Okay, but there is some school of thought out there that says, well, wait a minute, people are afraid to go out. They don't want to do this. And so I think it remains to be seen what's really going to happen. I would bet I'm more bullish, I think, than maybe some, but there may be a group of people out there that just have no plans to go to a restaurant anytime soon. And so, that's going to impact, the ability for those restaurants to perform. So there is an issue out there. It remains to be seen.
And just a real world example, I mean, you're going to follow the data. That's kind of Peter's takeaway here. Let's follow the data. But, Uber today reported an uptick in demand, and they don't have enough drivers. And so the question you're going to ask is, do they not have enough drivers because of this stigma, this fear? It's one thing for the rider who may take a ride once a week. Their risk factor or risk analysis is very different than the driver who's taking, a dozen people every couple hours. And so is the lack of drivers an impact to Uber due to COVID or something else? And time will tell, obviously. But if you're not aware of those subtleties going into one of these disputes, you're really going to miss a big issue. So I do think stigma damages, depending on the nature of the business, the location of the business, will be something that the expert and the attorney are going to have to look at closely.
Mm-hmm.
And public perception and comfort level is the subject of our last polling question, which is, which of the following restaurant scenarios are you currently comfortable with? And there's no right answer to this one, and select all that apply. Are you comfortable only with delivery or takeout? Are you comfortable with outdoor dining, indoor dining at 25% capacity, 50% capacity, or 100% capacity? So check all the ones that you personally feel comfortable with right now. All right, and this spread is about what I anticipated as well. And considering that Orange County is now in orange tier, and several of the counties in California are moving to orange tier with an indoor dining, how does this public perception factor in for both Patrick and Peter? What are your thoughts?
My first thought is just that this sort of survey data whether it's a mock jury or you get an expert who goes out and actually does an admissible survey analysis, in the right case could be powerful evidence, either to rebut assumptions or to establish the assumptions you want to make. If you just have an expert making assumptions based on their personal perception, I think you're at a real risk for, adverse ruling in terms of admissibility.
Yeah, I would agree with that. And I think the numbers are spot on as to what I would think at this point. But I also agree with respect to the survey, because let's say you don't get an industry expert or you can't find an industry expert for a certain aspect of a case. You can ask your financial expert to go out there and do research and do an empirical study, do a survey, and bring that information back. It's one way of getting around a situation where you can't find that, that specific expertise. So you've got to go out and do some work, and you got to do your own research. And so you can use your economic expert to do that.
And then it's kind of a final takeaway point. We mentioned some of the shutdown orders, and those were highly specific based on location. So how would different orders in different areas impact your situation, and how important are the details in that context?
Well, for me, I mean, listen, if you had a situation where you had a government shutdown order and the restaurant had to remain closed and could not reopen this entire period, I mean, obviously your revenue in that case is zero. I mean, there's no way you could operate, right? So you have to understand what these orders have dictated, and they've changed over time, right? So you really need to do a complete inventory as to what has impacted that business over time. We've seen a lot of these things, one order orders them to shut down, they can open for a period of time, they got shut back down again. You got to make sure all of that stuff is in your model. Are you going to get embarrassed?
Disneyland, Disney World. I mean, so if the expert hasn't taken into account as one of the factors the location of the business, there you have two, pretty good examples, similar management, similar, marketing, but two very different locations, and one could open and one could not. So yeah, I think, Peter, that's exactly right. I would just have a heightened level of paranoia about not overlooking COVID, but then also the nuances. What are all the ways this could impact this particular business? That needs to be in your model, in your consideration. And if it's not, you're just open to a broadside attack where your expert may not even be allowed to testify.
And then we have a couple minutes left, and there is one question in the question box, and this is for Patrick. In your sinking building case, what happened to the exit-only signs?
I'm sorry, the
sinking building case, what happened to the exit-only signs?
Oh, I see. This is an inside joke. So I'll just laugh and say, you got to watch the 60 Minutes episode on the Millennial Tower. But I don't know that there's a substantive response to that question. I suppose if the building sinks too far, you're not going to see the exit-only sign. And then if there's a fire, you have compounded damages. I'm going to let it go at that, Marco.
Great. So that was the only question that we had, and you all have addressed all of the issues thoroughly, and I think we've all learned something today. So for any of the attendees, if you have additional questions or we weren't able to get to your question, please feel free to reach out to any of us directly. Our contact information is up on the slide deck. It will be in the slide deck that's sent to you, or you can find us on the Nossaman or GHG websites respectively. Lastly, if you have time, a reminder to please fill out the survey that will appear once the webinar concludes. We would love to get your feedback on today's program. And thank you again for joining us today, and please stay safe.
Thanks, everybody.
Very much. Thanks, Natalie. Thanks, Peter. Thanks, Marco.
Everybody.